Hello everyone. First of all, apologies that I'm posting a video after a very long gap. Well, part of the delay is because I was researching on a very important topic, which is about post-dating of patent applications, which is a slightly typical topic, which required me to research a bit regarding what exactly the provision means. So what I intend to do in the present video is that I'll be dealing with the provisions relating to post-dating of patent applications as provided under Section 9 and Section 17 of the Indian Patents Act. And as you are already aware, I have been making those videos regarding preparation for the patent agent examination. So I would be making another video which would deal with answering questions that have been asked in the previous year's question paper. So this video would only relate to the provisions that are there for post-dating of a patent application under the Indian Patents Act. So let us first see why post-dating of patent applications is actually required. Let me just clarify that post-dating of patent applications under the Indian Patents Act is only available for ordinary applications that you file. So you cannot post-date any convention application as such. The overall effect of post-dating of a patent application is to shift the priority date of a patent application by a specific period. So this makes me think, why would I want to change the priority date? Because obviously if I change the priority date of my application, then I risk the novelty and inventiveness of my invention. But this option of post-dating is provided so as to address a specific situation wherein you filed an ordinary application and you are required to file a convention application within 12 months of the priority application or the priority date, and you missed out that date, you didn't file it. So what you can do is you can shift the priority date by around 6 months from the original date, and then based on the shifted date you can file a convention application taking the priority from the new priority date or the new shifted date that you get. However, this also entails the risk that within the period in between the original priority date and the new priority date, there might be some prior arts that might affect the novelty or inventiveness of your invention. So that's the risk you are taking. And this was identified in Justice Iyengar Committee report on revision of patent laws of 1959, wherein the committee referred to a statement in Terrell which provided the justification for post-dating as the applicant getting more time to file his complete specification for putting his application in order. But again, at the same time, it identified that there is a risk that the patent could be invalidated by some disclosure or maybe any prior publication that exists in the interim period between the original priority date and the shifted priority date. You will understand this better when we move to the provisions, but as of now, you just consider it as a shifting of the original filing date or of the priority date of your ordinary application in India. So as I said, post-dating of patent applications is available for ordinary applications. So ordinary applications could be filed either as a provisional application or as a complete specification. So we'll see what are the different provisions that are provided under the Indian Patents Act related to provisional and complete specifications and how we identify the priority date for these applications that are filed. So Section 9(1) addresses a situation where a provisional application has been filed first, and in this case, if you are filing a provisional application and then subsequent to that you are following it up with a complete specification, so you have to do it within a period of 12 months, which is provided under Section 9(1). Here, the effective date of the application or the priority date would be the filing date of the provisional specification. So the day you file the provisional specification, the application along with the provisional specification, that is considered as your filing date, or in other words, the priority date of that particular ordinary application. Section 9(2) deals with a situation where there may be two or more provisional specifications covering different aspects of an invention. So maybe these inventions could be cognate inventions, or maybe one could be a modification of the other invention, and these are covered under different provisional specifications. So what you can do is, if all these inventions could be combined together so as to form a single inventive concept, what you can do is you can file a single complete specification derived out of combination of these two or more provisional specifications. So Section 9(2) provides you with that benefit that you can derive one complete specification out of two or more provisional specifications. However, if you are doing so, then the filing date of the earlier provisional specification is considered as the effective date of the application or the priority date. So if suppose you have filed a provisional application today and you file a provisional application tomorrow and you are deriving a complete specification out of these two, so your priority date or the effective filing date of the complete specification would be the date of the first provisional application, which is today. Section 9.3 deals with a very peculiar situation wherein you have filed a complete specification already. Suppose you file it today and then you realize that probably the complete specification does not define the invention in the best possible manner, or maybe you require some more details to be filled into the complete specification. So what you can do is, as an applicant, within the 12-month period from the date of filing of the complete specification, you can request the controller to treat the first filed complete specification as a provisional specification. So what you do is, whatever complete specification you file, you ask the controller that it should be converted to a provisional specification. And then section 9.1 provides that you can file a complete specification from a provisional specification within a period of 12 months. So within the period of 12 months, you can follow it up with a subsequent or second complete specification, counting from the filing date of the first complete specification. So very briefly, you file a first complete specification, then you ask the controller to convert it to a provisional specification, and then within 12 months of the first complete specification, you file a second complete specification. So the effective date of the application would be the filing date of the first complete specification. Section 9.4 deals with another peculiar situation, and this is the first post-dating provision that is provided. It provides that where a complete specification has been filed in pursuance of a provisional specification under section 9.1 or section 9.2, or maybe if you have filed a specification which has been treated as a provisional specification under section 9.3. In a way, what we are talking about is the second complete specification in respect of the section 9.3. So that would be considered as the complete specification. So what happens here is, you have filed a provisional specification and then you file a complete specification, maybe under section 9.1 or section 9.2 or even section 9.3. So the applicant can request before the grant of patent that you cancel the provisional specification and post date the application to the date of filing of the complete specification. So this was the effective filing date of your provisional. Now what you do is, you have cancelled the provisional and you have asked the controller to shift this effective filing date to the date of the filing of the complete specification. So this is how you are post-dating your application to a later date. Coming now to another provision related to post-dating, section 17 subsection 1 provides for the powers of controller to post-date any patent application, and this is done on a request made by an applicant after the filing of the application or before the grant of it. So this provision applies to both the cases where the application is accompanied directly by a complete specification, or maybe the application is first accompanied by a provisional specification and then you convert the provisional specification to a complete specification. So it addresses both the scenarios. If the application has been filed along with a provisional specification, then the provisions of section 17.1 are subject to the provisions of section 9, as I'll be explaining. Again, the intended purpose of the provision is to change the priority date of the ordinary patent application that you have filed, and we'll refer to it as the effective filing date. So in a way, when you have filed an application, you can post-date it at the risk of affecting the novelty and inventiveness of the invention, as we have already discussed earlier. There is a proviso to section 17.1 which provides that post-dating cannot be to a date later than 6 months of the effective date of filing. So one thing I would like to clarify here is that section 17.1 cannot be used to extend the time period that is provided under section 9.1. So in a way, you filed a provisional specification and then forgot to file the complete specification within the 12-month period. So then you think that, okay, what I'll do is I'll shift or post date the provisional specification to a later date, maybe by 6 months, and then from that shifted date I'll count the 12-month period. That is not allowed. So there is a very clear judgment by the Delhi High Court, Tandy Pack versus Oswald Trading, where the court said that post dating of a patent can only be done from the date of the filing of the complete specification. Now the date of filing of the complete specification here refers to the effective date of filing of the complete specification. So when you file a provisional specification and follow it up with the complete specification within the 12-month period, the effective date of filing of the complete specification is the date of filing of the provisional specification. So that becomes the effective date. So the overall effect of this is that you can change the effective filing date, or as we refer to it as the priority date of your ordinary application, by a maximum period of 6 months. But that is only applicable where you have followed the regular procedure of filing a provisional specification and then followed it up with a complete specification within the usual time limits or within the prescribed time limits. It is not to rectify a mistake where you did not follow the timelines under section 9.1 or 9.2. Yet another important provision is section 136 subsection 3, which provides that convention applications cannot be post-dated under section 17.1. So this only relates to ordinary application. That's what I have been emphasizing since the very beginning. So now let me try and explain to you the provisions with the help of illustrations. So we will be considering two cases. First, where the ordinary application has been accompanied by a complete specification. So the complete specification is the first application that has been filed. Here you have filed the complete specification, and this is the effective filing date of your application, of your ordinary application. So now under section 17.1, what you can do is you can request the controller to shift this effective filing date by a maximum period of 6 months to a new effective filing date. So this is how you are post-dating the application to a second effective filing date. And the effect of this is, if you have to file a Paris Convention application in some other country, or maybe follow it up with a PCT application, so your priority date would now be counted from the second effective filing date or the post-dated effective filing date. You can take the 12-month period from the new effective filing date. Let us now consider scenarios where your application was accompanied by a provisional specification first, and then you followed it up with a complete specification, so that this provision of post-dating would be subject to section 9 requirements. So considering section 9.1 first, you filed a provisional specification, and within 12 months period you filed a complete specification. So in section 9.1, the effective filing date of the application is that of the provisional specification. So this is the effective filing date. So even when you file a complete specification, it would be considered to have been filed on this effective filing date only. So this is the priority date for your application under section 9.1. So now what you do under section 17.1 is you request the controller to shift this effective filing date by a maximum of 6 months. So this is the effective filing date for your post-dated application. So now you have shifted the priority date of your application by a maximum of 6 months. And as I had already mentioned, this is only possible when you have filed a provisional specification and followed it up with a complete specification within the 12-month period. So it's not the case where you only filed a provisional specification, did not follow it up with a complete specification, and then you think of requesting for a shifting of the effective filing date. No, that is not possible. So your post-dated effective filing date, which is EFD2, becomes your priority date now, and any 12-month period for the purpose of filing a convention application or a PCT application would be counted from this. Section 9.2 is somewhat similar. So you have one provisional specification, there may be another provisional specification which is later to the first one, and you are deriving the priority from both these applications and filing a complete specification. Again, the provision, as I have explained in section 9.1, applies here as well. The earliest provisional specification forms the effective filing date, and the treatment is same as that in section 9.1. Let us now see how this would play out for section 9.3. Section 9.3 provides that you filed a complete specification. So this becomes your effective filing date 1. And then within the 12-month period from this effective filing date, you requested the controller to convert this to a provisional specification and then filed another complete specification. So in a way, your first complete specification was to be treated as a provisional specification, and then you filed a subsequent complete specification. In this case, the effective filing date of this complete specification would still remain to be EFD1. This is same as what we did in section 9.1. So now under section 17.1, the applicant can request the controller to shift this effective filing date 1 by a maximum of 6 months to another date, which is EFD2, which becomes your new effective filing date or your new priority date. So again, as I had already explained, any 12-month period for filing a conventional application or maybe a PCT application taking priority from this Indian ordinary application would be counted from the effective filing date of the post-dated application or the effective filing date 2. Let us now see how section 9.4 plays out. It's a very peculiar section. Here you have filed a provisional specification and followed it up with a complete specification. The provisional specification has an effective filing date EFD1. So under section 9.4, the applicant can request the controller to cancel the provisional specification and shift the effective filing date to filing date of the complete specification. So this is how you have post-dated your effective filing date to the date of filing of the complete specification application, which I have mentioned as EFD2. So here your EFD1 is completely out of the picture, and maximum that you can post date under section 9.4 is 12 months, obviously, because you file a complete specification within 12 months of the provisional specification. So that is the maximum that you can go to. So here under section 9.4 you post date your patent application by a maximum of 12-month period. So this is your first step of post dating. Now if section 17.1 is also applied, that becomes a second step of post dating. Let us see how that operates. So now for the purpose of section 17.1, this becomes the date of filing of the complete specification, EFD2. Now the applicant can request the controller to further shift this effective filing date by a maximum of 6-month period under 17.1. So here you have shifted the effective filing date by another 6 months, a maximum of 6 months, to a new effective filing date, which is EFD3. So by application of section 9.4 and section 17.1, you can shift the effective filing date or the priority date of your application by a maximum of 18 months at the risk of losing the novelty and inventiveness in view of any prior arts that may feature between this 18-month period. So this is all about post dating of patent applications. In a nutshell, it is to change the priority date of your ordinary application. With this, I am ending my talk regarding post dating of patent applications, the provisions. If you have any questions, please drop them in the comments box and I'll be happy to answer those. If you have liked the video, please hit the like button and subscribe to the channel so that you get regular updates regarding any videos that I'll be posting in the future. Also, I would look forward to your constructive comments regarding what needs to be improved so that I address those shortfalls and maybe try and improve for better understanding of yours. As I had mentioned, my next video would deal with the questions that have come in previous year's question papers. So keep on following the channel. Thank you very much.